All right, everyone, welcome. Thank you for coming to this panel on privacy as a human right. We're going to try to maximize the time we have for dialogue. I'll give you a little overview of the path that we're going to follow and some brief background information on the panelists. So, Bob to my right, sorry, dyslexic. Bob Destro is a professor at Catholic University of America Law School, law professor, and is going to speak today on some aspects of privacy under U.S. law, the history of some of the Brandeis's reasoning about privacy, which was so prescient, and give you a kind of a context for privacy as it finds support in U.S. law under the Constitution and the state constitutions as well. Then to my left, Al Gambas. Hey, come on in. We're going to do a plug for DigiMe halfway through.
Well, we truly not only believe that it is a fundamental right, we prove it is a fundamental right.
There's the plug.
Just in case you're interested.
So Al Gambas is from the State Department. He does human rights work there. He's an attorney, and he's going to talk about both U.S. law and international law, where privacy derives from some of the most fundamental international legal instruments. The bottom line up front for me on this area is, as I've told Deb and everyone involved in PPR, I think the only way we untie the Gordian knot of problems around privacy to the benefit of the public is if we start from the premise that privacy is a fundamental right. It is protected under U.S. and international law, and if you skip over that premise, I don't think you can protect the interests of the public now or in the future if all you have is a utilitarian calculus about people's personal data. It always seems to skew in ways that undermine the privacy rights of ordinary people. I've had some experience with folks in Silicon Valley. I know a lot of folks in leadership in Silicon Valley, and I was funded by a venture capital firm for several years out of Silicon Valley. And the surprising thing for me was to discover the degree to which people in Silicon Valley are almost ahistorical in their thinking about certain topics. In other words, if it came before the internet, it doesn't really matter that much. They won't say that to you, but that's sort of the operating mentality. Now, the problem with this is concepts like human rights have a long history. People sacrificed, suffered, and some died to give us these principles. And if we overlook what the past has to offer us in terms of teaching us how to protect people's fundamental freedoms, we create a future that could be a nightmare for our kids and grandkids. Welcome. Human rights are essential to protecting human dignity. They're essential to protecting freedom. They're essential to protecting democratic discourse. They're essential to protecting the most powerless, the weak against the strong, the powerless against the powerful, the poor against the rich. They're essential to preserve our ability to criticize and resist abuses of power, whether by public or private sector actors. Human rights, if you flip them sort of to the positive, human rights should be seen as unleashing human potential, social potential, and economic potential. And a society that stifles or ignores human rights is a society in which human potential is not fully realized. Here in the free world, we largely take our human rights for granted. Whenever I teach, I find it's students from countries where human rights are threatened who care most passionately about them because they understand how important they are. And we're at a stage now in our history where we're going to have to reassert the fundamental right to privacy as something that we need to pass on to our kids and grandkids, or they're going to suffer. Human rights education is important because every generation has to relearn, in a sense, why human rights matter, what they are. The mission of the nonprofit that I founded is to promote human rights in the digital age and to explore the intersection between timeless human rights principles and digital media and culture. I'm now a chair of human rights at the Institute of World Politics here in DC, so that's my full-time job. Last background point. It's not the task of government bureaucracies, whether they're national bureaucracies like the State Department or international bureaucracies like the UN to protect human rights. It's not just their job, it's everyone's job. Human rights are protected when everyone sees them as a common good that needs to be protected, and that includes those shaping the digital landscape in Silicon Valley. There's a huge public education piece that we need to do with the leadership of Silicon Valley around human rights. So we're going to get into this topic in a minute, and we'll start with Bob. But before he makes his remarks, I'll just make one last point about where I think this is headed. I'm a political pragmatist, so I understand that there are many people who don't care about human rights. I understand that the economic forces driving the behavior of companies in Silicon Valley are powerful. And I would say there's a day of reckoning coming when either through some form of public backlash against the abuse of people's personal data, or through episodes like the Sony Pictures hack, where we discover that there's a profound national security interest in protecting this data, and also in not over-collecting and over-retaining consumer personal data. And our hope is that before we see some sort of backlash, which will manifest itself in legislation that will probably be, I don't know, what do you say, technologically unnimble, clumsy, possibly punitive, like Sarbanes-Oxley, that type of an approach. Before that happens, it would be far better if the private sector would self-regulate to protect human rights, to protect the right of privacy. They would, benefit the public. They would benefit national security. They would benefit their own reputation and standing with consumers. And I would submit that the place for the private sector to do this is around an understanding of privacy as a fundamental human right. That's the ground to stand on if we're going to protect privacy and unleash potential for future generations who are going to live, and eat and breathe in a digital landscape. So with those remarks behind us, let me start with Bob.
Before you let go, what is privacy? Doesn't mean much to me. The White House can't define it.
Right. Well, you're pointing your finger at one of the great debates. The European Union, of course, is ahead of us on this. So,
I couldn't care less.
Yeah.
But what is privacy? Before you protect my privacy, I want to know what the heck you are all about.
Sure. Well,
my privacy may be interfering with a lot of commerce and a lot of daily life.
Right. So your personal data is in a sense, is sort of implicit in the term, is in a sense an extension of your person, right? So whether it's your medical data, your genetic data, data about who your friends are, your habits, what you read, your opinions, your thoughts, this is very much an extension of your person. And access to that data, particularly if it's significant access, offers many opportunities for powerful actors to interfere with your freedom, B, in worst case scenario, actually manipulate you, control you, or block your freedom. And so all of the definitions that are out there orbit around that type of concept, that it's an extension of the person.
Can we elide privacy and just put in access to my data and access to your data?
You know what we'll do? How about this? I have a suggestion. Why don't you save these questions till after the speakers finish, and then they'll answer them and you'll have some more background. How about that? Okay?
We're going to try.
Go ahead.
Okay. Let me go back here to, the discussion about the right to privacy it really got started as such, as we understand it today, back in 1890, when Warren and Brandeis wrote their famous article in the Harvard Law Review. And basically what they were doing back then is trying to figure out, look at all this new technology. But they were talking about pictures, and newspapers that could be mass produced. I mean, and they were saying, look, he says, what we want to know is there some principle? That's why I kind of highlighted the term principle here, which can properly be invoked to protect the privacy of the individual. And so, the question, what is privacy? Really, really good question. And if it does, what is it? And later, as you kind of read through the article, you begin to see, in the context of another sentence, he says, the principle is that of what they call an inviolate personality. Okay, the inviolate personality. Who are you? What is it that makes you uniquely you? Now, what I'm going to do, and I'm going to tell you that when you look at the different laws that Matt has given you the slides, I added a few additional things to the slides. If you look at every single one of them, you will find that they're all lacking in something. Okay, they're all lacking in something, and what I would argue is that they don't start from the same first principle. It's that principle that we're looking for. And you can see them kind of dancing around it. They're getting there. It's almost like you're kind of orbiting the black hole, but you haven't quite hit the target yet. And what we see is that the European data directives, are much more person-centered. Because here in the United States, we still deal with everything as a question of property. Okay? And that's really what it's. The data belongs to the person who collected it, right? And in Europe, they're inching more toward the data belongs to the person about whom it describes. Okay, but even that dichotomy, I heard somebody on the panel just before this one talking about, well, we are a lot more business friendly, than maybe the Europeans are. Well, I think again I consider that to be a category mistake. Why? Because what we're really talking about is, are we friendly to human beings? What makes us the people that we are? And what you'll find is that if you look at the 11 state constitutions, and this link would take you there, and you would compare them all, they're okay. They basically start from the proposition that Warren and Brandeis did, that the right to privacy is, quote, the right to be let alone. And I would say even today, that made sense in 1890. It does not make sense today. Because the whole point of the Google business model is not to leave me alone. It's basically to use the data that I am generating to then get me to do things. So the whole point of it is to use a more pejorative term, as Matt did, is to manipulate me.
Could I just ask,
Sure.
In the 1890 context,
Yeah.
I'm not familiar with it.
Right.
What did leave me alone mean?
Well,
What was it they were trying to guard or defend you against?
Well, what they were doing back then is he traced the common law development, of property rights, and eventually they got to the point where, which is it's exactly where the state of Virginia is today, as a matter of fact, is they were talking about a celebrated case in New York where a woman was dancing in tights, and somebody took a picture of her while she was doing this dancing, and it would have been scandalous. And could you then go out and sell the pictures of her? And he goes a little earlier back and said, well, where do we get this idea of intellectual property? And how eventually over time you went from the labor of a person's hands to the crops of his field to the labor of his or her mind, which then gets protected when they publish it. And then he says, but what happens if you're just writing in your diary and it's never supposed to be published? Could somebody take that, and publish it? And the answer is, yeah, they could. And he said, there's something wrong. There's something missing, right? There's something missing. And so if you look at the Warren and Brandeis article, it's like, there's got to be some principle out here. Let's figure out what it is. And when I listen to these privacy discussions, you'll see it here. It says no one shall be subjected to arbitrary interference. Okay, that means by definition, you can be subject to interference. It's just not supposed to be arbitrary. Same thing, arbitrary and unlawful interference. Okay, so it's presupposing you are this little citadel, and then somebody else is intruding. Okay, and the most interesting and most recent, iteration of a constitutional protection is the one in Missouri, where they're saying electronic communications, we're going to protect you not only in your persons, your papers, your homes, your effect, and your electronic communications, or access to your data and communications. And we say, well, why is that? Why do we do that? Well, because you're not invited, right? If I have a right to protect my person from unlawful interference, and Brandeis and Warren talk about that in their article, where did the law of battery come from? Is that I wasn't allowed to touch you in a way that you weren't going to consent to. The law of assault then proceeded, logically from the law of battery, because I shouldn't even be put in fear that you're going to touch me, which is the difference between assault and battery. And now it's kind of like, well, you can touch me in ways now that nobody ever dreamed about back then. And you can touch me in very profound ways that I may not even be aware of. I mean, that's the whole idea. And so if you look at what the European Data Directive, which just is beginning to be implemented right now, it says personal data means any information related to an identified or identifiable natural person. Now you notice natural person is different than juridical or corporate person. What we're talking about here is a natural human being. So what we're talking about is what is, and I hate to put it this way, but the idea that Justice Douglas used to talk about in terms of a penumbra, the shadow around the center, that basically it's the person, and kind of in all their manifestations. And so what I thought I would do is to give you kind of an idea of what I'm talking about when I talk about a fundamental right to privacy. And privacy may not really be the best idea for it. It really is kind of the integrity of the person and their relationship to data. So if we start with this little idea of like, well, what do we mean by privacy? You'll notice that the colors are Google's. Because the big threat to privacy is not so much the government, it's the private collection of data. Okay, and I'll tell a little story about that. So if we have, if we're looking at privacy and we say, all right, well here, this is a medical, you're talking about medical confidence. Well, here is your EMR. Here's your electronic medical record right there. So we got a huge database with your electronic medical record. So if I have that, I have some very useful information about you. And then I can get your credit card records, and I find out, what you buy, where you go. Get your tax records. Okay, then I can get your bank records, and I can get your cell phone records, and your Google search records, and your Facebook records, your public, your social media. I can get your Safeway card records, so I can now find out what you like to eat. And then I can get your set-top box records and find out what you like to watch. And some of the stuff about net neutrality is not so much about net neutrality at all. It's about data. Okay, and then I get your double helix. Because after you've gone to 23andMe and had your swab, and you have your whole DNA sequence, what do I have when I aggregate all this data? I have you. I have you in a way that Brandeis and Warren could never have imagined in a million years. And the question, what can I do with that information, is profound. We haven't even thought through what can be done with it. But I'm going to end, more or less where I began, but I'm going to start with the proposition that maybe common law isn't the way to deal with this at all. I mean, it gets us partway there, but it's not going to get us all the way there.
Define common law for the
Okay, the common law is the judge-made law that's developed over time by judges, who will say, hey, look, he ran over my cow. How do I measure the value of the cow?
as opposed to legislation.
As opposed to legislation, right? Okay, and legislation is going to be where the action is over the next few years because judges really don't quite know how to deal with this. And so I would suggest to you that one of the best places you could look is in Jewish law. Because Jewish law, it has been said many times that rights as a category doesn't make sense in Jewish law. Jewish law rests on the idea of mitzvah, that the idea of incumbent obligation. Because as the late Professor Robert Cover of Yale said, a right without an obligation, he said, and I quote, is a sad, almost a pathetic thing. So if you have a right to privacy, but there's nobody else on that other side who has a duty to respect it and to take care of that data, then you've got nothing. You've got absolutely nothing. And so that when you say, well, okay, what is this, your question, what is this right to privacy? Well, what is, and my Islamic law friends will say, well, rights don't make sense to us either. We want to talk about justice. So what does justice require when, if I aggregate all this data, I have you in a way that nobody else has you? And what does justice require? And it's out of that question, comes this idea of the people who collect data maybe are stewards of that data. They're stewards of that data, and even though they can use it for the purposes for which it was collected, and I cited the privacy policy and everything else, if you start selling it to people, then we're going to have a problem with that. We're going to have a violation, certainly of your privacy, of your property rights. But here in Virginia, just across the river, Virginia doesn't have a common law of privacy, unlike many other states. Why? Because the legislature intervened a few years ago. And in a case involving former Redskins player John Riggins, there was a case where the real estate company was going to sell his house. They said, come and see John Riggins' house. Well, that's a fact. It was John Riggins' house. But when they put John Riggins' picture on the flyer, the court said no. The fact that it was his house, that's a publicly known fact. He says, but you can't use his image. Right? You can't use his image. And I think that where we're going here is that we need to be thinking together of what do we mean today when we say the illicit use or the use of someone's image. Do I have a human right at least to know about, or do you have an obligation to tell me if you're imaging me? I certainly could not be grabbed off the street and taken into Virginia Hospital Center and completely imaged. But I do have, and they couldn't stop me. But that would be the law of battery. But if I go to McDonald's and drink out of a cup, they can completely image my DNA by what I leave on the straw. So the question of what is privacy, I think this needs to be worked out. But to me, it adheres in that image in the middle. The image in the middle of this graphic, who is Bob Destro? And the answer will be found by aggregating and manipulating all this data to basically fill in everything. What I look like, what I think, what I feel, who I like, who I hang out with, what I believe, and everything else you can imagine. So to me, it's an open question, what is the right to privacy? But one thing I can tell you is we can define what your image is. And that can be done with some precision. Okay, thank you very much.
When you said Jewish law, did you mean Talmudic law?
Yes, halakha. Yes, the the oral law of the Jewish tradition, because that the central principle of a bar mitzvah, bat mitzvah, is I accept my obligations.
All right. Well, he covered a lot of the ground that I was going to cover. I'm going to try to shorten my talk here, which is probably a good thing. The less I say, the better. First, I'd like to thank Matt and Dr. Peel and Ms. Rulin for inviting me to participate in this presentation. It's an honor to be here today. The fact is, I used to attend here. In fact, I used to sit out there for an awful lot of lectures, so it's good to be back again. In fact, about 5 years ago, I think, here at the law school that I first met Bob, so good to be reunited. I'm going to start out with a quick story. The doctor was invited to a formal dinner party one evening, but she arrived rather late, having missed cocktails in the first course, and after apologizing profusely to the host and hostess, she took her seat at the other end of the table and sat down next to a lawyer. She turned to the lawyer and explained that the reason for her delay was that one of her patients had called just as she was about to leave the office, and the patient really needed her help. Unfortunately, the telephone consultation took a while, and she just couldn't escape. And then she said to the lawyer, "Do you think I should bill for the consultation?" And the lawyer instantly replied, "Of course you should." And the next day, the doctor got a bill from the lawyer. Now, I'm glad you laughed at that. Ordinarily, the doctors don't laugh as much at that joke as the lawyers do. And when the lawyers don't, it's because they're taking notes.
Let me write that down.
And I told you that for a reason. I want you to know that I'm providing my talk here free of charge. I'm not billing any of you or the conference holders. I didn't ask him for any of your names and addresses, so I can send you bills. But I should add, I'm only speaking for myself and not these two. So I don't know.
I want my smoothie.
And of course, I should also give the requisite legal caveat here that I'm speaking solely for myself and not for my employers. So with that, what I'm going to try to do here is give you, as Matt said earlier, sort of a brief history of an awful lot of history, so bear with me, and then go into some of the threats that I think are looming, if not already upon us. In the modern era, there's been a roiling debate in international law about the origin of human rights and the hierarchy of rights, and these two debates are inextricably linked. On the one side are those who contend that human rights are purely a human construct generated and bestowed by governments. This view goes at least back to Karl Marx, and there are even earlier proponents. I would include, for myself, I'd include the American Revolution patriot Thomas Paine as another advocate in that view. And this view holds that all rights are equally valid once they're enacted, and that they are culturally dependent, at least to a certain degree, and it's the function of government not only to enact them, to create them, but to adjudicate among them as to which one will prevail in any given situation. It's a tough job, but that's what judges are paid to do. Somebody's got to do it. In these situations, the principal factor in the process of deciding these matters is determining which outcome is in the best interest of society as a whole. Now, the critique of this view is there's a number of critiques, but a couple I want to briefly mention for you here. One, it's that the primary focus is not on protecting the individual and the individual's rights. It's more on what's in the best interest of the society as a whole. And the second critique would be that if the government can enact them, then the government can also limit or repeal them. In other words, effectively, government has all the power. The individual is at the mercy of the government. And so it follows then that the government can repeal and adjudicate as they wish. There's little accountability for the individual who's been aggrieved vis-a-vis the government. And you just reduce the entire structure to social utilitarianism, or to put another label on it, it's a tyranny of the majority. It's whatever the government decides is in the best interest of society as a whole, regardless of what actual rights the individual may have. Now, granted, that's that's a little bit of a caricature because I don't have a lot of time to go into more of the complexity and the nuance involved in all that, but it'll suffice for our purposes here today. On the other side of this debate, there are those who hearken back to earlier eras, such as the French Revolution, the American Revolution, the English Civil War, the 30 Years' War, on and on back, at least to the Magna Carta, and some can even find strands of this back in Plato and Socrates. And in each of these earlier eras, political philosophers were thinking and writing and developing concepts that we sort of take for granted today, such as Langton's separation of state and church, Saxby's one man, one vote, Locke's life, liberty, and property, Rousseau's popular sovereignty, Montesquieu's separation of powers, James Madison's checks and balances, and so forth and so on. As one reads through their work and studies the history of the eras surrounding them, one sees very different strands of thought slowly building on top of one another, and this gives you a more consistent development in the progress of thought about human rights. And so you get a hierarchy of rights as you view what they have to say. And at the top of the human rights pyramid are what we call first order rights. They exist independently and objectively, and they're not dependent on any human construct. They predate government. They're fundamental to human social interaction, and they are universally applicable at all times and in all places. And our role is then simply to identify them when we see them, and then respect them as such by instituting them in our legal systems. We don't create them and then circumscribe them as the times dictate. These are first order rights. They've always been in existence. We may not have realized that they were there, but they've always been there. And then our obligation is simply to abide by them. Now, you can probably see where I'm going with this. Admittedly, I'm squarely in the latter camp. Universal fundamental human rights means that every individual has them all the time, no matter what. And for the sake of my own argument, I'm going to go through some of the thinkers who have contributed to this view. Probably the most prominent example of this comes to us from the Declaration of Independence, Thomas Jefferson being the document's primary author. And if you can put up the... So it says, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent to be governed, that whenever any form of government becomes destructive to these ends, destructive of these ends, it is the right of the people to alter or abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness." Note that what we're talking about here are self-evident truths. That's why the document was called the Declaration of Independence and not the Resolution of Independence. The word declaration is actually a legal term of art that indicates a factual state of being that is merely recognized by a legal instrument rather than created by it. So here the Declaration of Independence is declaring to the King of England that the former colonies are not merely deciding to secede from his sovereignty, but are in fact already independent, and they're just alerting him to that fact. And the closing paragraph of the Declaration reiterates this point if you'd like to look that up later yourselves. And the basis of this ultimate fact they are informing the king is a litany of other self-evident truths. So we hold these, plural, truths to be self-evident. What are these truths? Well, first, embedded in the notion of human equality that is referenced there is a rejection of the whole concept of the divine right of kings. As George Orwell pointed out, there's no such thing as some people being more equal than others. It's just an absurdity to even talk that way. Now, I don't have the time to go all the way back to the foundations of the rejection of the divine right of kings and how that leads to the notion of popular sovereignty, but it's there. Second, I want to point out to you that there are certain rights that are God-given. We are endowed by our Creator with them. Now, without getting distracted by the whole existence of God thing, the point is that they are not bestowed upon mankind by governments, This is a rejection of that notion. That would simply make it self-referential. Instead, they're self-evident. So that even if you're an atheist, you know they're there. Even if you can't explain their origins, they're there. They're unalienable, meaning that they're inherent in the individual. It's not as if you can even give them away if you wanted to. Regardless of the existence of a government, they exist. And so they can't be taken away by anyone, whether another individual or a government. Third, the rights of life, liberty, and the pursuit of happiness are just 3 of these rights, these first-order rights. There are more, as we'll see. It says among them is what I'm pointing to there. Fourth, note that the whole reason governments are established, the whole reason they exist, is to protect these first-order rights. That, in the view of the Declaration's signers, was the proper function of government. To create the conditions in the society whereby people can not only exercise their universal fundamental human rights, but where the exercise of those rights can thrive. Fifth, the legitimacy of the government is dependent on the consent of the governed. Now, this is at that time was a radical, even though it wasn't a new concept, it was a radical concept, which is why you actually had an actual war over this. And moreover, if the government fails to create the conditions whereby people can exist, can exercise their universal fundamental human rights, that government forfeits its legitimacy, and the people have the right not only to reform it, but if necessary, to overthrow it. Now, none of these ideas sprang ex nihilo from the head of Thomas Jefferson, as I said. These concepts have been developing in Western political thought for centuries, and many a graduate school dissertation has been written on the progression of these ideas. But I'm going to leave it at that because our time is short. So what we know then is we have these first order rights. They include the right to life, liberty, and the pursuit of happiness. And the signers of the Declaration were so convinced of this that at the end of the Declaration they wrote, "And for the support of the Declaration, with a firm reliance on the protection of divine providence, we mutually pledge our lives, pledge to each other our lives, our fortunes, and our sacred honor." In other words, they were so convinced of what they were saying that they were willing to risk everything they had and literally to stake their lives, their very lives on it. And that's how self-evident they believed that this all was. So now, where might we go to find some of these other rights that Jefferson alluded to? Well, how about the Bill of Rights? I'm skipping over the Articles of Confederation, I'm skipping over the Constitution itself, I'm skipping over the Federalist Papers, and a bunch of other prominent documents at the time, and skipping right to the Bill of Rights, because it's probably the most obvious American articulation of fundamental human rights from that era. In fact, George Mason, one of our most prominent champions of the idea of having a Bill of Rights, a man who was probably the most vocal agitator for it, lived just across the Potomac here, down at Gunston Hall, a little bit past Mount Vernon. If you get a chance, I'd encourage you to go visit his home down there. He was so adamant that the federal government live up to the ideals set forth in the Declaration of Independence with respect to fundamental human rights, that at the Constitutional Convention he refused to vote for the Constitution that passed because it lacked any mention of such rights, let alone any mention of the government's obligation to respect them. So, what are other rights that are implicated in the first 10 amendments to the Constitution? I'm just going to list for you very quickly the broad strokes without actually citing the text itself. You can look these up yourself later on. The amendments obviously are going to be much more specific. So, in the First Amendment, we see freedom of religion, freedom of speech, freedom of the press, freedom of association, the right to citizens to criticize the government and to demand action. In the Second Amendment, the right to self-defense. In the Third Amendment, the right to the integrity and inviolability of one's property. The Fourth Amendment, the right to privacy and to the integrity and inviolability of one's property again. Fifth Amendment, the right to life, the right to liberty, the right to privacy, and again, the right to property. Sixth Amendment, the right to liberty. Seventh Amendment, the right to property. Eighth Amendment, the right to liberty. The Ninth Amendment is a recognition that there are additional fundamental rights beyond even those listed in the Bill of Rights. And the 10th Amendment is a restriction on the federal government from interfering with those rights. That's a pretty good list, especially considering that's more than 200 years ago. Of course, this conference and this panel are supposed to focus specifically on the right to privacy, so I'm going to skip most of the amendments and just focus on the Fourth Amendment here, which I think we have right there. Terrific. Note that this includes, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Persons, houses, papers, and effects. Back when this was written, that was a pretty comprehensive list of all the things that you could own. The key word there, I think that I want to focus on is the word effects. It's a very broad term that was sort of intended as a catch-all for anything that didn't fit into the previous categories in that list. Essentially, all your tangible goods that you own that don't fall in any of the previous categories would be caught by effects. And back in the day, aside from your own ideas, there really wasn't much, if anything, that couldn't fall into that one of those categories. In an era now, fast forward 200 some years, in an era where technology makes people aware of a whole lot of other things that are both intrinsic to who they are and produced by who they are, they begin to understand that they have a proprietary interest in those things. And that's what spawned Justice Brandeis's article. He actually discusses this phenomenon in the article. He cites, among things, he talks about one's reputation, one's image, one's voice, and one's ideas as things that are intangible, but ought to be protected under this right to privacy. And so when you or I decide to share any of these things with others, we ought to be able to decide when, where, and how we want to do that. Now, I don't want to get too caught up in the discussion of the right to one's privacy, because we're supposed to be focusing on property. I want to focus more on the privacy side of this. And that more specifically is about the right to not have one's property exposed in ways that you might not want it to be. The key takeaway is that the property and privacy are very much intertwined, and that as technology has developed, the risks that technology presents to one's privacy also increase. So fast forward with me now to just after World War II. The world is recoiling in shock and horror at the abuses of the Nazi regime and the aftermath of the Holocaust. The great powers are not quite as great as they once were. New powers are emerging. Suffering in Europe and Asia is still there, and you're witnessing revolutions across North Africa and the Middle East, and even in parts of Europe. And yet, in 1948, the world was able to come together at the United Nations and write up a list of universal, fundamental human rights that they all agreed should stand as a bulwark against the abuses of government going forward, and they call it the Universal Declaration of Human Rights. Now, it's been signed and ratified by every country in the world, except for Saudi Arabia today.
Every country in existence in 48.
Every country in existence in 48, except Saudi Arabia, has now signed the Universal Declaration of Independence, Human Rights. Sorry. And while it's not that popular document in the United States in the public mind, it certainly is in other countries, particularly in countries that have experienced a lot of repression. It is, in fact, the most widely translated document in the world, even more than the Bible. I'm not going to go into a lot of great detail about it because Bob already talked about it, but I wanted you to know that that was the next step in the progression. And then in 1966, governments around the world came together again and passed the International Covenant on Civil and Political Rights. And 10 years later, it went into force as a treaty, and it's now been ratified by 168 countries. There's about 200 countries in the world today. So that's an awful lot of the world's governments also respect that document. We have adopted a number of laws in this country that implement the ICCPR, some of which I'll briefly. The Electronic Communications Privacy Act the pen register laws that we have, the Stored Communications Act, our laws regarding wiretaps, just a few examples. So all of that is either a very long prelude or a very brief overview of how we got to where we are now. What I'd like to now address is the question of why does this all matter to any of us? Right now, approximately 43% of the world's population is on the internet. They have access to the internet. That's about 3.4 billion people, give or take. And there are about 8.7 billion devices currently connected to the internet. However, it's expected that in about 4 years, that number will increase as much as tenfold. So, we're talking more than 75 billion devices connected to the internet by 2020. And you are seeing what's called the Internet of Things coming about. And it's coming right at us. It's going to hit us right between the eyes. Every one of the devices that we're talking about are going to be capable not only of doing the function that you wanted it to do, but it can also collect data on your use of it. And what's more, it can send that data to someone else, and you may have absolutely no idea that it's doing that, but by purchasing it, you've consented to the manufacturer collecting your data and doing whatever the manufacturer decides the manufacturer wants to do with it. Now, why does this matter? So, about 16 years ago, I was on active duty in the Pentagon. I'm an Air Force JAG in the reserves. And at the time, then Colonel Dunlap, who went on to become a General Dunlap, gave a lecture at the Pentagon, and he talked about how legal assistance, which is one of the things that JAGs do for the military, would become a prime tool, prime way that we were going to engage in warfighting. Now, legal assistance primarily consists of drafting wills for members of the military, powers of attorney, maybe reviewing a landlord-tenant lease, or a car, you purchase a car, those kinds of things. But he argued that the work that we do as legal assistance attorneys was going to be much more vital in warfighting, because the enemy was going to be able to steal the identity of military members and wreak havoc with their identities. They can generate all kinds of problems. As we see today, even if you're not in the military, if somebody steals your identity, they can do all kinds of damage to you. And he argued that the lawyers in the military were going to have to sort all that out for our military members, so the military members could focus on the mission. And fast forward now 16 years, and I'm beginning to see that maybe he wasn't such an outside-the-box thinker at the time. We saw, like last year, I guess it was, ISIS published a list of 100 military members and their personal data on the internet, and suggested that people who were sympathetic to the ISIS cause do harm to them. That's just our military members. Think of what China can do with all the data that they stole from OPM. I personally got 2 letters from OPM telling me that my information had been stolen. I can just imagine what China can do with my information. And it's not just my information, by the way. When I get my security clearance, I've got to provide to Uncle Sam a whole lot of information about my family, about my contacts, about my friends. None of those people signed up to have Uncle Sam allow China to have their information. But now I have no idea what China's going to do with it, when they're going to do it. So that puts me and all my contacts in a much more vulnerable position. With the Internet of Things, all of these devices, as I said, are going to be able to collect data on you. So imagine, if you will, you wake up one morning before work, and you just reach over to your nightstand, you pick up your iPhone, and you punch some buttons on there, and you open your garage door, and you program your driverless car to go to McDonald's and pick up your breakfast for you, and you order your breakfast over your iPhone, and as your card goes through the drive-thru at McDonald's, they just drop the bag of breakfast items through the rolled down window while you're taking a shower back at home. Your car comes and picks you up, you get in the back seat, you eat your breakfast as it drives you to work. Sounds pretty good. That's, there's a lot to be said for this new technology. But when you think about all that data being collected on you, every one of those steps along the way, who's collecting that data? What are they going to do with it? And what are the chances that the people who are collecting it might be hacked? And then they lose that data, and you have no idea. So you've got the vulnerability of the people who are collecting it, you don't know what they're going to do with it. And you've got the vulnerability of the people who steal it, and you don't know what they're going to do with it. I think that's probably enough to lay out the problems. So I'm going to stop there. You can let your imagination run wild on how this stuff can be used in the future.
Maybe we'll eat less McDonald's. Questions?
Have I scared you?
How about,
I got 2 OPM letters too.
I think I got through it. I think we're not working to a solution here. I guess I was looking for a solution.
Okay, so
That's a problem. One second.
Sure.
I spent 7 years in the U.S. Senate on contraception, abortion, genetic non-discrimination, and the HITECH Act. And we have no concept here. This isn't about search and seizure. This is not about criminal. You show the Fourth Amendment, and it's almost irrelevant to the issues that we're talking about in the main sessions. The thing that I concluded after all of that work was that we really need to update the concept. I talked to Deb and a lot of colleagues here. Calling this privacy, we're losing the public.
Right.
I mean, I understand we're talking in legal sense.
Yeah.
It's not about privacy, and I talked to some colleagues, they say it's about property. It really is about the information about me and who owns it. And I've had a big argument with Target. I've written some nasty things, and a few things I've written over the years. The idea that I go into a store and everything that I buy is used to profile me in some way, and that information is then sold through surrogacy. And so we're all familiar with Diggs articles and some of the other things that have been out there. And now this morning we're coming to the logical conclusion that we all know that we're going to be facially profiled, so I can't even use cash when I go into the shop. So we're going to have to deal, I'm talking the U.S. rather than international, we have to deal as a nation with this issue much more proactively than I think we are. And that really is what information, access you have a right to, what does Target have a right to, what does the government have a right to, what do my health providers have a right to, what is their rights of access to me, to information about me, and what is their rights of use. And you can't deal with one or the other, you've got to deal with both. And that's what we did when we rewrote HIPAA. We said, we're going to keep genetic information within HIPAA, which is a vastly defective regime. But I remember speaking here down the street here about almost 10 years ago and saying we're going to rewrite HIPAA, and everyone from Kennedy's office and others, we're never going to do it. We did it 3 years later.
Right.
We did it 3 years later. But I think the Europeans, and what we heard earlier today,
Way ahead of us.
fascinating, are ahead of us.
Yep.
They understand this. By virtue of the technology, and I love what you said, because I used to be in the software industry years ago, and I understand that the mindset out there is ludicrous. But I teach law and ethics at a university. I've taught for this course for several years, and my students are freaked out at the end of it. I say, well, your generation is going to have to deal with this, because you can take this information, as I know Latanya and others are going to show, and profile people and wipe out every civil rights protection we have by virtue of using surrogacy.
Right.
And I wrote about this in the Atlantic a couple years ago. But we're going to have to deal with the access and use of information about people.
But
I love the Constitution, but frankly, searches and seizures of property doesn't do it.
the reason that's all up there is just to establish the fact that there is a right to privacy.
There is a right to
There is a right to privacy, and this is evidence that we have that right. These documents exist to show that you have that right. I'm going to take issue with you on one little thing. I think you're absolutely right that the concept of the right to privacy and the right to property are inextricably interlinked. But I don't want to lose the fact that privacy is in fact a fundamental human right that plays a huge part in this, and it's not just about property.
We need some outlines around it, I guess.
Let's try, as we were losing, one more question.
Well, just a
comment, the bigger problem is that healthcare is not a fundamental human right. And what we're talking about is the privacy of our health information where we make, you know, choices to go see doctors and get
Right.
healthcare. And I think that's,
See, I think if I could just kind of pick up on your comment, is that, you know, I had a former student of mine, former research assistant of mine, went over to down to Richmond to talk about, you know, could we write a new privacy law for Virginia? And he came in exactly the way most lawyers do, like looking at the Fourth Amendment. He came back feeling like he had gotten the hell beat out of him by Google.
Yeah.
You know, and he says, all of a sudden I realized that they see any discussion of robust understanding of my information is mine. I mean, it's not that you can't use it. I can give you maybe a license or something. You know, but he says they see it as an attack on their business model.
Well, it is.
Well,
It is. It's an existential threat. It's an existential threat.
Well,
He's been patient.
Yeah, go ahead.
One thing. So I'm not a lawyer. I'm a designer, and I've been
Right.
working with computers since the late '70s, and I've watched this happen. The slide, your best slide is the slide we have all of that stuff up.
Right.
When you look at that slide, try and imagine what all of that data is. Have you ever actually pulled all of that data together? You can grab some of it, and you can go over to Google, you can get everything.
Right.
You can go over to Facebook,
Yep.
download a lot of stuff. A lot of this other stuff you can't get access to, so you don't
Right.
actually know this notion that it can be aggregated. And maybe
It already is.
It already is.
Listen,
It's already
it already is in some sense, but in terms of how it's evolved and why the law and regulation part is so discontinuous with it. If in 1996, 20 years ago, if I sat here and I said to you, you know what's going to happen? Every person in the world is going to carry a transmitter that's going to be on all the time, and it's going to be collecting data on them all the time. And not only are they going to do it voluntarily, they're going to pay $200 or $300 a month for it.
You would have been deemed crazy.
What would you have said to me?
Right.
If I said
See,
that in
what we're
1996?
talking about, what we heard this morning about China, existed
Everyone
10 years ago here. If you know the right databases, you know the right brokers, we already have that here.
Brokers, but the data is shit. I mean, the stuff that the data people are selling.
Well, some of
is
it's,
a
I mean,
lot
they're
of
still
crap.
trying to sell me an MPH on
It's a
Google,
lot
and
of
I got-
crap, and that's part of the
Degree
reason
in a
why.
couple
That's part of the
others.
reason why it violates people so much.
So, I
Because
mean,
it's got a lot of bad
There's a lot
data.
of,
That
but
too.
even if it's good data, you know, I'm exposing myself in such a way that, I mean, that's where the concept of privacy kicks in. But this is a double-edged sword, as he said so eloquently this morning. I use that same term, and it's going to be used for profit.
Yeah.
But it's going to cause a lot of people a lot of harm. And if I can't control that information, nothing we're talking about right privacy has meaning at all.
Right, that's right. And
I'd
that's,
like to ask three lawyers, because I'm not a lawyer. What's your take on limiting digital data sharing to regulated open marketplaces, places like Facebook, and closed clearinghouses, things like fusion centers and law enforcement and Social Security and other government databases?
Limiting it legislatively?
I'm not sure. What options are viable?
well, to me, the only viable option is to go back and focus on that person in the middle, me, you, and say,
If that person actually had a data locker, if that person
Problem is
could actually hold it all,
Well, there are a lot of private sector actors that are trying.
it just doesn't exist.
No, but that's not my point. My point is just like with respect to intellectual property. You know, it's a decent analogy, right? That I should be able to have a right to go in and A, find out what you've got on me. You know, B, see how people are using it, who are you giving it to.
Describing HIPAA. You're describing what we did on HIPAA.
Right.
We said there is an owner. We don't say ownership, but there is a right of the practitioner
Right.
to use the data. For example, and I remember writing a provision on this when we did the rewrite to be able to do process improvement, quality assurance, your own marketing and work within your practice or your hospital. We even allow some fundraising things, which I wasn't keen on. But aside from that, that information is about you and is protected. Now, we don't do anything about the collection of it, but we regulate the disclosure of it. And that is a continual battle because that is the approach you have to take.
It is the approach.
Control the collection, and I'm suggesting humbly that the U.S. be far smarter and try to control the sharing. Because if you don't collect the data, it's gone, and it may hurt the whole society. But allow the collection while regulating the sharing, you're sort of keeping it in a box.
Compartmentalized. One of the big problems is that the law always lags behind the technology.
My security file.
Thank you, guys. Yeah, just a little bit. Thank you.
Yeah, I know. I understand.
I mean, the only thing that's safe secure in the federal government anymore is my retirement file.
You know what?
It's on paper.
Maybe. Yeah. Oh, yeah.
It's
Exactly.
on
If it's on
paper.
paper. Yeah.
It
If
takes
it's on
months to
paper.
get it.
We're going to stop when there's no one left in the audience.
That's close enough.
It'll be like C-SPAN when the members of Congress give their speeches.
So how do you?
Thank you for coming.